An offer is an objective manifestation of a present intent to contract, demonstrated by a promise, undertaking, or commitment, definite in certain terms, and communicated to an offeree. Objective manifestation of intent. An offer must give offeree a reasonable expectation that offeree is willing to enter into a contract. And would a reasonable person believe the communication is offer inviting acceptance? Definite and certain in its terms. Terms included must be sufficient to allow a court to enforce the contract, like quantity, time for performance, price. Vague terms or terms of negotiation are insufficient. Communication to an identified offeree. Offeree must know of the offer and have the power to accept it. Advertisements generally are not offers unless highly specific as to the quantity and clearly indicate who may accept. UCC offers, the quantity must be certain or capable of being made certain. Requirement output contracts, no unreasonably disproportionate increase in quantity allowed. Missing terms is okay, particularly price, if parties clearly intended to make the contract and there is a reasonably certain basis for giving a remedy. A termination of offer. An offer may be terminated by an act of a party or by operation of law. Acts of party include 1, revocation of offer, 2, rejection of offeree, 3, lapse of time. Offerer can set a time limit for acceptance, at the end of which offeree's powers of acceptance automatically terminates. Operation of law. 1, death or insanity of either party. 2, destruction of proposed contract subject matter. And 3, supervening illegality. Revoking offers and irrevocable offers. An offeror may revoke her offer, which effectively terminates the offer and the offeree's power of acceptance. Methods of revocation. 1, unambiguous statements by the offeror to the offeree. 2, offeree becomes aware of offeror's unambiguous conduct or statement indicating an unwillingness or inability to contract. Limitations on revocation. Revocation is only effective upon receipt of offeree. Offeror cannot be revoked once it has been accepted. Unilateral contracts. Start of performance makes the offer irrevocable for a reasonable time to complete performance. Start of performance must go beyond mere preparation. Irrevocable offer. An offer is irrevocable if A, option contract, which is a promise to keep an offer open. Common law, consideration required in exchange for this option. UCC, no consideration required. B, UCC firm offers. A merchant's offer made in a signed writing that assures the offer will be held open is irrevocable for the time stated. No consideration is required. If no time stated, irrevocable for up to 3 months. Detrimental reliance by offeree. Reliance must be reasonable. Rejection of offer. Rejection of offeree terminates the offer and the offeror's power of acceptance. Method of rejection: 1. Express rejection, effective when received. 2. Counteroffer, terminates original offer and becomes a new offer. Bargain or request for information are not counteroffers. 3. Conditional acceptance, terminates original offer and becomes a new offer. Look for terms such as if, provided, so long as. Offer to mow the lawn. Offeree says, I accept if you also trim the hedges. This is a new offer. Original offeree is now the offerer. Exception, a condition that would be included anyways. Implied warranty, does not terminate the original offer. And 4, acceptance with additional terms. Common law, acceptance must mirror the offer. Acceptance with additional terms creates a rejection and counteroffer. UCC depends on whether both parties are merchants. Contract involving non-merchant. Terms of the offer govern. Contract is formed, but additional terms are excluded and considered mere proposals to modify the contract. Both parties are merchants. Additional terms become part of the contract unless certain exceptions apply. Acceptance arises upon offeree's clear expression of assent to the terms of the offer. Offeror controls method. Offeror is the master of the contract and can dictate the manner by which an offer is accepted. The mirror image rule, which is common law, states acceptance must mirror the offer's terms. It cannot add, omit, or change the terms of the offer. Under a UCC acceptance, 2 issues often arise. 1, acceptance with additional terms. Are both parties merchants? If yes, the contract is formed with additional terms unless either A, additional terms materially change the offer, B, offer expressly limits acceptance to the offer's terms, or C, offeror objects within a reasonable period of time. If they are not both merchants, then the contract is formed but with additional terms. There's also acceptance by shipment. It's when a merchant may accept an offer to buy goods by either providing a promise to ship the goods, usually written confirmation, or promptly shipping confirmed goods. Shipment of non-conforming goods acts as acceptance, but may give rise to a breach. Then we have the mailbox rule. Offers and acceptances transmitted via mail. However, the mailbox rule does not apply to email. It becomes effective upon either dispatch or receipt. Offers effective upon receipt. Rejections and counter offers are effective upon receipt. Acceptance is effective upon dispatch. Method of communication. Unless otherwise provided, offerers invite acceptance in any reasonable manner under the circumstances. A sends an offer to B via email, and B accepts via text message. Valid contract has been formed. If acceptance is via instantaneous two-way communication, such as phone, it is treated as if the parties are in each other's presence. Limitations. If the offer stipulates acceptance is not effective until received, the other controls. So offerer can opt out of the mailbox rules. If offeree sends both a rejection and an acceptance, first to arrive controls. Options contracts, acceptance is effective upon receipt. Revocation. Revocation is effective only upon receipt. Mailbox rules do not apply. Acceptance by performance. Unless acceptance is limited by terms of the offer, offeree may accept by partial performance for bilateral contract or complete performance, unilateral contracts. Unilateral contracts, a complete performance is required. Offeree is not obligated to start or complete performance. Failure to perform does not give rise to breach because no contract is formed absent complete performance. Revocability, offer may become irrevocable upon the start of performance until completion. Notice only required upon completion. Offeree is not required to give notice upon start of performance, but must notify offeror within a reasonable time upon completion. Bilateral contracts, partial performance gives rise to acceptance. Offeree must make offeror aware of acceptance. Offerors requiring acceptance by promise. An offer requiring acceptance by promise may still be accepted by performance if 1. Offeree begins to perform, and 2. Offeror knows offeree has begun performance and acquiesces. Note, an offer may always limit methods of acceptance. Consideration and substitutes for consideration. Consideration is a bargain for exchange for legal value between parties. There must be a benefit to promisor or detriment to promisee, a required element of every contract. Bargain for exchange is the promise must induce the detriment, and the detriment must induce the promise. Detriment is an obligation to do or refrain from doing something one would otherwise not be obligated to do or refrain from doing. Pre-existing duty. A promise to perform a pre-existing duty or obligation generally does not constitute consideration. Acceptance is promise to pay a debt after the SOL has run its binding. Invalid consideration. The following do not constitute consideration: promises of gifts or conditional gifts, illusory promises, a promise where there's no obligation to perform, A promises to do B's chores if he has time. And then there's promissory estoppel. Courts may enforce a promise if 1, the promisor reasonably expects a reliance by promisee, 2, promisor acts or refrains from acting in detrimental reliance, and 3, injustice will occur without enforcement of the promise.